Good afternoon, dear professors and dear guests. It is a great honor for us to virtually host you in the first seminar of Comparative Law Seminar Series. We have very distinguished guests, our professors, colleagues, students. Welcome all, and thank you for being with us today. Today we will listen Professor Borghetti's presentation on civil liability reform in France, and the participation to the Zoom meeting is actually remarkable. Thank you very much again. So without a moment's delay, I would like to give the floor to an outstanding comparative law scholar in Turkey, Professor Ergun Özsunay. Professor will honor us with his keynote speech. So please, Professor.
Thank you so much, Professor Baysal. Dear director or directress of the Center for Liability Law, dear colleagues, dear, and if there are dear students, I have the honor to make an introductory speech on the occasion of the Center for Liability Law at Kadir Has University. So to the director of the center and other organizers for granting me such an opportunity to introduce, on the one hand, this new center to the relevant circles, and on the other hand, to introduce Professor Borghetti to our colleagues in Turkey. As you know, French Code Civil is a monument and is the intellectual achievement of enlightenment. It is a splendid reflection of the French legal culture. Again, as everybody knows, for a while, the Code Civil provisions remained unchanged for a long time. Remained unchanged. Why? Because the French lawyers, scholars, and Cour de Cassation interpreted the rules of this 19th century in the Civil Code in a rather dynamic manner, according to the rules, principles, and rules of teleological interpretation, and thus French Cour de Cassation could create even a strict liability for damages caused by things, shows, through by means of interpreting Article 1384. And then the guardian, custodian, was held liable to compensate damages suffered by victims of accidents, particularly industrial accidents. Nevertheless, the lawyers felt that some parts of the Code Civil should be revised and modernized. When we celebrated, I was also in Paris, the bicentenary of the Code Civil in 2004, we were awarded the code will be revised and modernized soon. In fact, in 2004, we witnessed the revision of the provisions on divorce. So it was followed after this revision. The revision was followed by other revisions in 2006, security interests, 2008, reform of the statute of limitations, prescription, in other words, and in particularly in 2016, we witnessed the reform of French contract law, and the revised provisions entered into force in 2018. Needless to say that German contract law reform had impact on the reform of the French law of obligations. The modernized rules of on contracts of 2016, as I said, came into force in 2018. 2018. And with that action, also some articles in Code Civil were revised. And on this occasion, I would like also to remind the endeavors of Professor Catala. Catala did contribute a lot to the reform of Code Civil, particularly French contract law, to a great extent. So his avant-projet de réforme du droit des obligations et de la prescription was published in 2005, and I taught the reform endeavors in my classes when I lectured on major legal systems in the world today, when I lectured French system or French law crisis or French rights crisis or French legal sphere. I taught the endeavors in French law for reform and revision. So as you see, the French reforms of the law of obligations have not been yet completed. Now, French law on civil liability was one of the areas also needed to be reformed. So therefore, today, we are going to listen to presentation of Professor Jean-Sébastien Borghetti on endeavors relating to modernization of liability law. By the way, a reminiscence. Professor Birli Symposia organized by my former institute, by Institut de Droit Comparé, with the Turkish lawyers within the framework of the Cour de Cassation, Turkish Cour de Cassation. And also, I remind our cooperation and our debates with our colleagues within the frameworks of Semaine Juridique Turco-Suisse and Österreichisch-Türkische Juristentage. So therefore, in those conventions, we used usually to examine the law reform endeavors, particularly in the field of liability, civil liability, responsabilité civile. And we used to check the practice of law in our countries and the development of law and types and trends regarding the development of law in our countries. So therefore, I do hope that some kind of contact would be established with Kadir Has University Center for Liability Law and with some French law schools or French law institutions. Now, let me come to introduce you our colleague Jean-Sébastien Borghetti. Borghetti is a distinguished French legal scholar of today's generation. He is a professor of private law, professor de droit privé in Paris 2, but he educated in Paris 1, Panthéon, Sorbonne, and he got his PhD degree also in Paris 1, Panthéon, Sorbonne. So his topic of his PhD was on product liability in comparative perspective, la responsabilité du fait des produits, une étude du droit comparé. Professor Borghetti has been teaching, as far as I understand, he has been teaching French contract law and in English language, of course, and general French civil law. Particularly, he teaches also advanced French contract and tort law, comparative law, contract design, economic analysis of contract, and tort law. As regards the main scientific activities and responsibilities, I have to mention he is member of the European and New Technologies since 2018. He was a member of the board of the European Center of Tort and Insurance Law in Vienna. Then he is also working in some working groups under the auspice of the French Ministry of Justice on contract law and on some issues, on some problems of law of obligations. Further, he is a member of Académie Internationale de Droit Comparé, European Law Institute, and also ein Mitglied der Gesellschaft für Rechtsvergleichung, German Association of Comparative Law. So I am not going into details mentioning enormous works and contributions carried on by our course, but I would say his last work on French revised, renovated contract law, published in German, Die Reform des französischen Vertragsrechts, a publication of Mohr-Siebeck, and the last year, 2020, French civil liability in comparative perspective. So it is an insightful examination of the distinctive law of civil liability in France. So I think I have to terminate my speaking here. So it is again a pleasure for me to present you Professor Borghetti. So the floor now is our Dean, Başak Baysal. Thank you very much for listening to me.
Yes, thank you.
Thank you, Professor. I mean, with your permission, I will take the last word, I mean, after the presentation, and that's why the floor now is again to Dr. Topukçu. Thank you.
Thank you, Professor. Now I would like to give the floor to Associate Professor Dr. Nilay Arat. She is the director of the Institute for Liability Law, which is officially established last week. And we also regard this conference as the first event of the Institute. So please, Professor Arat.
Thank you. It's my great honor and pleasure to welcome all of my distinguished colleagues, judges, lawyers, our students, and guests to the official opening of the Comparative Law Seminar Series and the Institute for Liability Law. If you allow me, I would like to offer a few words on our new institution and then leave the floor to our distinguished colleague. The Institute for Liability aims at academic research integrated with practice and industry, and being a venue for fruitful academic aspirations in the field of Turkish private and public law, and also international liability law. The Institute aspires to take part in and support academic research projects, organize educational seminars and symposiums. The Institute furthermore fosters academic relationship with other institutes worldwide as well. I'd like to mention any collaboration or touch with any national institute alike, as this institute is a pioneer at national level in the field of liability law. It's our pride, actually. Therefore, it's my great pleasure on my part and on behalf of Kadir Has University Faculty of Law to announce the establishment of the Institute for Liability Law. This good news comes with the launch of another treasured event, that is to say this comparative law seminar series. Also today, it's a great honor for us to have a grand opening academic activity with the valuable keynote speech referring the significance of comparative law of our honorable mentor, Professor Ergun Öztunay. It's always a great pleasure for us to be a part of the same academic community with him. I also would like to extend my warmest welcome to our guest today, our distinguished colleague, Professor Jean-Sébastien Borghetti from Pantheon-Assas University. Dear Professor Borghetti, with a hope that today inspires ideas and give way to a fruitful and stimulating discussions, I leave the floor for your valuable contributions. Again, thank you for honoring us here today, please.
Thank you very much for these kind words. It is a great pleasure and a great honor for me to make this presentation, and this inaugural presentation of the Institute for Liability Law. And I want to thank you and Professor Baysal for this invitation, Professor Öztunay for his very kind words, and Kadir Has University for this invitation. So I'm extremely proud to be the first one to speak in this context. I hope I won't disappoint you. And so I'm going to talk on French civil law reform. So I have prepared a PowerPoint. I hope you see it. Does it work?
Yes, we are seeing it.
Okay, so civil liability reform in France. So I'm afraid Professor Öztunay has deprived me of my introduction. Nevertheless, I will say a few words. Because, as you know, so French adopted its civil code in 1804 at the time of Napoleon. And the civil code, so the Code civil, as we call it in French, is indeed a major piece of legal scholarship. And as Professor Öztunay has said, it has remained practically unchanged in the field of the law of obligations until very recently. Of course, many provisions of the civil code have been modified over time, especially in the field of family law, as you might expect. But in the field of the law of obligations, so mostly contract and tort law, the provisions have remained or had remained almost unchanged since 2004. And then at the beginning of the year 2000, after we had celebrated the 200th anniversary of the Civil Code, we started in France to talk seriously about the reform of the law of obligations. And I won't go into the details of the process, but it was finally decided that contract and tort law, well, rather contract law on the one hand and civil liability law on the other hand, would be reformed separately for, let's say, political reasons. And so in 2016, we had a reform of, well, so that was our original civil code. And then in 2016, we had a reform of contract law. And about this, I should say that there is something of a paradox about this reform of contract law, which of course is not the subject of this presentation. But you might know that in the year 2000, well, starting in the 1990s, where people in Europe started to talk about a possible harmonization of contract law in Europe with many projects, the principles of European contract law, the PECLs, but also the draft common frame of reference and the project for a common European sales law, etc., etc. There was a very strong opposition in France to these projects. French lawyers, at least the majority of French lawyers, did not want to have a unified European contract law. They wanted to retain a specific French contract law. But the paradox is that when we eventually reformed French contract law in 2016, there was a strong European influence. And I think that it's fair to say that French contract law as it stands today after the 2016 reform is actually, well, the national contract law which stands closer to, or closest to the, unification projects like the PECLs. The new French contract law is actually very European. It's very close to the PECL. So this, of course, raises a question. When the reform of civil liability takes place, as it hopefully will happen, will it also be very European? well, it's too early to answer that question. What is certain is that in 2017, so quite shortly after the contract law reform was adopted, the French government published a reform bill on civil liability. And this reform bill hasn't been passed yet. It hasn't yet gone to Parliament, but it hasn't been shelved either. So it's still on the agenda, but so far it hasn't been adopted. But if the reform of civil liability is to take place in France, it will almost certainly take place along the lines of that 2017 reform project. So what I would like to do is to talk to you about this reform project, which gives us, I would say, an image of what civil liability reform will be like in French law. But in order for you to exactly understand what what the input of this project is, I think that it is necessary to start and have a look at French civil liability today. So first of all, I'll talk about French civil liability today, and then I will look at French civil liability tomorrow. So what civil liability in France will be when the reform is adopted. When talking about today, I shall be talking about the current state of French liability law, and then I will say a few words about the reform process. And then talking about tomorrow, I will first address the content of the bill, and I will then end up with the future of the bill. So first of all, let us talk about today. I'm sure that so many of you are familiar with French civil liability law. Certainly Professor Ozounet is, but some of you might not be that familiar. So I hope I won't bore you too much if I say a few things about French liability law as it stands today. And I think that it's all the more interesting as French liability law is actually quite specific. It does stand apart if you look at the different liability laws in Europe. French liability is certainly rather specific, idiosyncratic. So I will say a few words about liability in contract, liability in tort, and about the relationship between contract and tort. And the reason why I'm encompassing both liability in contract and liability in tort is that, as you will see, the French reform project does cover those two legs, I would say, of civil liability. So liability in contract and liability in tort. So let us start with liability in contract. So the basic rule of liability in contract in French law is expressed at Article 1231(1) of the Code Civil. So just to make one point clear, the reform of French contract law has entailed a renumbering of many provisions in the Civil Code. So even some provisions which haven't been modified on the occasion of the contract law reform have been renumbered. And this is the case, for example, of today's Article 1231, which actually has the same substance as the former Article 1147, but it has been renumbered. And so this provision, whose text you have under your eyes and which I probably need not read, basically sets out a strict liability in contract. So as you know, many legal systems like Germany, Swiss, and Switzerland, and I'm afraid I don't know Turkish law very well, but I would assume that since Turkish law very often follows Swiss law, then Turkish law must have contractual liability based on presumption of fault, but this is not the French system. The French system has basically strict liability in contract. So the debtor must pay damages as soon as he doesn't perform the contract unless he's excused by force majeure. So liability is strict. And what also is important is that all types of harm can be compensated as soon as they were foreseeable at the time of the conclusion of the contract. This means that, for example, French contract law doesn't see, well, doesn't have a problem with compensating moral harm in case of breach of contract. Admittedly, it doesn't happen very often because it's not that often that moral harm is caused by breach of contract. But unlike many other legal systems, French contract law doesn't restrict the types of harm that can be compensated in contract. Let us now turn to liability and tort. So in the original civil code in 1804, there were only 5 provisions on liability and tort, only 5 provisions, which obviously is not much. Those were the articles 1382 to 1386, which have been renumbered on the occasion of the reform of contract law, but which haven't been modified. So only the number has changed, but not the substance. And the most famous provision is undoubtedly, former Article 1382, which has become Article 1240, which sets out what you might call, if you take a German approach, a general clause of liability for fault. Sometimes we even say very general clause, so clausula generalissima in Latin. So what does Article 1382 say? Well, its formulation is a bit outdated, even in French. So if you look at the translation into English, it may not be immediately, plain what it means. But if you translate that provision into plain English, as you should, then that's what it means. A person is liable for the harm caused by his fault. So it's a very general rule. You can hardly have a more general rule. Anyone is liable for harm caused by his fault. So quite obviously, this provision sets out 3 conditions for liability to arise. The first condition is fault. The second condition is harm. And the third condition is causation. So you will have noticed that unlike many legal systems, there's only 3 conditions. Many legal systems have at least officially 4 conditions: fault, harm, causation, and illegality. We only have 3. So let's shortly have a look at those 3 conditions. First condition, obviously, is fault. So we do not have an official definition of fault in French law. The Code Civil generally is not very keen on definitions. So if you look at the original Code Civil, you have almost no definitions. And so there's no definition of fault in the Civil Code. And French courts, especially the French Cour de Cassation, so you know how it works, and this is the highest court in civil matters. The French Cour de Cassation has always abstained from giving a definition of fault. It could have done so, but they have preferred not to give a definition. And the reason why they haven't done so is that, of course, they retain more discretion if there's no official definition of fault. So it means that, with no definition, the Cour de Cassation has more freedom to decide whether in a given case there is fault or there is no fault. So no official definition of fault. But then we nevertheless do have a definition. I mean, academics did draft a definition, that's their work. So we usually define fault as simply the violation of the duty. And this duty can be either the general duty of care. We don't have, discrete duties of care as English law has, for example. We just have a general duty of care. And we also have, of course, statutory duties. And what is important is that we have a very objective conception of fault. That is, you have fault as soon as there is a violation of a duty. And so the state of mind of the defendant is irrelevant. So you don't have to prove actual negligence or intention. It's enough that the defendant violated a duty. You don't have to prove that he did that intentionally or negligently. The violation of the duty is enough. And besides, a child or an insane person is at fault as soon as he violates as a statutory duty or does not behave as a reasonable adult. So children, small children, can be at fault under French law if they don't behave normally, but normally means behaving like an adult, a reasonable adult. So we have actually very broad conception of fault. You could say a very objective conception of fault. Now, if I turn to harm, here also, French law is quite distinctive, first of all, in that it doesn't have any list of protected rights or interests. You know that some legal systems, like Germany, of course, have, well, they make a distinction between protected rights and interests, or at least generally protected rights and interests, and rights and interests which are not generally protected. We don't have that in France. The rule in France is that any interest is protected, provided it is not unlawful. So it means that basically any harm can be compensated. And this includes, for example, pure economic loss. You know that pure economic loss is a very, I don't know if it's a hot topic, but it's a very classic topic in comparative law, because many legal systems do not compensate pure economic loss in tort law in the case of fault. And you know, pure economic loss is the economic loss which is not the result of a bodily injury or damage to a thing. But in France, it's not a problem for it. I mean, we compensate really all types of harm, provided the harm is not to something which is illegal. We also accept compensation of lost opportunities, so loss of chance. And we also have no problem in compensating lost profit expectations. So we have a very broad conception of compensable harm. And then if I turn to causation, here again, things are very, well, let's say French law is very general to claimants. First of all, there's no official definition of causation. Here again, no definition in the code, and the courts always abstained from giving a definition. So there was never, for example, an official adoption of the adequate causation theory, as was the case in other legal systems. And also, we do not use, at least officially, officiously it might be a bit different, but at least officially, we do not use restricting devices such as the scope of the rule, the Schutzweg der Norm, which is used in many legal systems, especially under the German influence. But we don't use that, and we have got no official test for causation. The only requirement we have is that the causal link between fault and harm should be direct. But this is rather vague. So it means that in practice, the courts have a lot of discretion. So you see, we have really a very broad liability for fault. It's extremely broad. But of course, we don't have only liability for fault. We also have strict liability regimes, or if you prefer, no fault liability. We've got several, what I would call focused strict liability regimes, most of which have been adopted or created by the legislature over the last century. So I won't make a full list of them, but I only want to mention 3 of them. The first one, obviously, is product liability, which is not a surprise because, there is a European directive on the subject. So the directive obviously had to be transposed, well, it had to be implemented in French law. So now it's in the Code Civil. We also have a special statute on traffic accidents, where we have what I call extra strict liability. Why is it extra strict? Because it's not based on fault, and there are very few defenses for defendants. So it means that if you're the victim of a traffic accident in French law, at least if you're not a driver, but if you are a pedestrian or a passenger in a car, you're almost certain to get compensated on the basis of civil liability. And then we also have, since 2016, we have a special regime for liability, not of, but for environmental harm. Okay. So those are the main, I would say, legislative regimes, but we've got other regimes. As Professor Ozunai mentioned, we have a general judge-made strict liability regime, which is based on now Article 1242, first paragraph of the Civil Code, which we call liability for the action of things, under which the keeper of the thing, you could say the keeper or the holder of a thing, is strictly liable for any harm caused by that thing. So if I have flower pot, the flower pot falls on your head, you're injured, I'm liable because damage was caused by my flower pot. I was the keeper of the flower pot. Maybe I was not at fault, but I was the keeper, so I'm liable. And this regime was developed as early as the end of the 19th century by French judges, and has survived, so to say, to this day. And then we've got also several liability for other regimes. So cases where someone must answer for damage caused by someone else, which is, well, which you find in most legal systems, but those are strict liability regimes under French law. And the two most important such regimes are, first of all, liability of parents for harm caused by their children, and liability of employers for harm caused by their employees. So, you know, if you take all these regimes, and if you take also liability for fault, which is very broad, it makes something, yeah, it makes for a very broad liability right now already. Very shortly also a few words on the relationship between contract and tort, because here again, French law is quite remarkable. First of all, we have a rule which we call non-cumul, so literally non-cumulation rule, but which should rather be called non-option. What is this rule? Well, it's a rule whereby as soon as you have a valid contractual relationship between two parties, if harm arises in the context of that contractual relationship, then only liability in contract will apply and not liability in tort. So let's say I'm a, you know, you've hired me to come to your house and fix your, you know, washing machine. So I come to a house and I fix your washing machine, but while I'm at your house, I don't know, I slip and I hurt you and you're injured. So I injured you on the occasion of the performance of the contract, but it's not really, you know, it's really on the, well, so to say on the side of the contract, because I did perform the contract and I caused harm to you, but not, it was while I was performing the contract, but there was not, literally there was no non-performance of the contract because your dishwasher is fixed. But while fixing your dishwasher, I injured you negligently. In many legal systems, I don't know how it works in Turkish law, but what I know is that in many legal systems, in such a case, you would either apply liability in tort, or you would have an option between liability in tort or liability in contract. In French law, in such a case, it's liability in contract. So we have a very broad conception of liability in contract, and we also have a very broad conception of liability of contracting parties toward third parties. So it can happen that if I do not perform my contract to the creditor, I will cause damage to a third party, to someone else. And since 2006, we have a rule developed by case law whereby any breach of contract is a source of liability in tort to third parties if it has caused harm to third parties. So if I have a contract to you and I do not perform the contract and it causes harm to someone else, to a third party, then I will be liable in tort to that third party, even though I had no contract with that third party and I had no commitment to that third party. So you see here again, a very broad conception of liability. If you're a bit familiar with comparative law, you know that in many legal systems, a big concern is, as some lawyers say, to keep the floodgates shut. So in many countries, there is deep concern that liability should not be too broad, because it is feared that if liability is too broad, then there will be too many actions, there will be the damages paid will be too important, and it will, stifle the economy. So this preoccupation is very strong, for example, in England, in Germany, in the United States. I don't know how it is in Turkey, but it's very strong in many countries. As you see, we don't have that problem in France. It's not a concern to us. But then if you follow, some English or German lawyers, then you may think it cannot work because liability is just too broad. So the system should crumble. But actually it does work. So we have open floodgates. I mean, we don't even have floodgates at all, and yet it works. So how come it works, even though we have such a broad liability? Well, it's not the subject of my talk, of course, but I would just like to mention 3 points which I think are important. The first one is that insurance in France is very widespread. So it means that in practice, most tortfeasors, most people who are, likely to become liable have an insurance. For example, I mean, almost all individuals have insurance for civil liability that they might incur in the course of ordinary life. So, for example, if my son, who is 4 years old, causes damage, as may happen, I've got insurance for that, and all French people have got insurance for that. So it's so having strict liability of parents for the children is not a problem because I'm not going to pay. It's my insurance, and it's very cheap, so I don't really mind. The second point, which is important, is that compensation in France is not very high. Well, of course, it's very difficult to compare the levels of compensation in different countries. And of course, if you compare France to some maybe poorer countries, it can be regarded as quite high because, well, France is a rather rich country, but the levels of compensation are probably lower in France than in other, similar Western countries. So we have very broad liability, but when it comes to paying damages, at least for economic damage, compensation is not always very high. And then the third factor, which I think is very important, is that the number of claims is not that important in France. Some countries are known for having, for having very strong litigation. Many people bring cases to the courts. This is the case, for example, in the United States, but even in Germany, you've got a great number of lawyers, and many cases are brought before the courts. In France, we don't have that many cases that are brought before the courts, or even cases that are settled out of court. So in theory, we have a liability which is very broad, but in practice, we don't have that many cases. So that's probably a reason why it works. But then, if it works, why should we change? Why should we reform civil liability? Because we are thinking about that. So that's really the question. So I'm now turning to the reform process with that question here. Why change? If a system works, why do we want to change it? Well, the first reason I think is that academics would like to change it because it makes fun. Academics like law reform, especially when they can get involved into it. I personally, but of course I'm not the only one, but like many of my colleagues, I was involved in the process of preparing the French reform of tort law. And I found that very interesting, sometimes also frustrating, because you want to have some of your ideas accepted, and they are not. So sometimes you're disappointed, but nevertheless you've got the feeling that you're part of the game, and it's very exciting and all that. So the academics are certainly pushing in that direction, but then the influence is, I'm afraid, rather limited. So it's not the academics who decide. So what are the other reasons? Well, I think a major reason, and it was also a reason why we reformed French contract law, is that we need to make, well, we think that we need to make French liability law more accessible and more legible. First of all, for ordinary people, because as I said earlier, in the French Civil Code, you only have, at least in the original Civil Code, you only have 5 provisions on civil liability, tort liability. So now you have more provisions because you've got provisions on product liability, on environmental damage. But nevertheless, most of the rules are not in the Civil Code. If you look at the French Civil Code on liability, you will not get a true idea of what French civil liability law is. Actually, you probably won't even get an idea because there's such a distance between the provisions and the reality of French law that it's impossible by looking at the code to have a fair idea of what French law is. So if we want to make law accessible to, to ordinary people, then we need to have a code which is more explicit and which incorporates all the rules that have been developed by case law over the last 200 years. Also, that there is, of course, a need to adapt liability law to changing social and economic circumstances. The French courts have done quite a good job adapting liability law to changing circumstances. As Professor Ozunai has said, as early as the 19th century, they developed that liability for things regime in order to address the problem of industrial accidents, and it was later used to address the problem of car accidents, traffic accidents. So the courts have shown that they were able to adapt liability law to the demands of the time. But nevertheless, the courts are not always in the best position to do that. And so it's only fair that the legislator should, take action and try to create, so to say, an up-to-date liability regime. And then the final reason, I think, is that, well, we reformed French contract law, as was said 4 years ago, now 5 years ago. And in a civil law system as French or Turkish law, well, the law of obligation is, must be taken as a whole. Contract law cannot be separated from civil liability law. So if you reform one leg, then you should also reform the other leg, because there are, many connections between the two, obviously. And so it's not a good thing to have, one leg that has been modernized and the other which is still mostly case law. So for the sake of coherence, we do need to reform also French civil liability law. And that's what we've been talking about for now nearly 20 years, actually. So everything started, as has already been said once again by Professor Ozunai, in 2005 when, well, in 2004, we celebrated the 200th anniversary of the Civil Code, and we started to talk about reforming the law of obligations. And very soon afterwards, in 2005, there was an academic project under the direction of the late Professor Catala. So an academic project was published, which purported to, to reform the whole law of obligations. And we call that the avant-projet or the projet Catala. So this was the first, academic proposal. And it was very interesting, but it was also open to criticism for several reasons, if only because it had been drafted quite quickly. So it probably wasn't as, well, as elaborated as it could have been. And also, as is often the case, well, the academics which did not participate in the Catala project wanted to have their own project. Academics have a great ego usually. So those who were not in the Catala project drafted another project under the supervision of another professor called Terre. And so in 2000, so that was the picture there is the first Catala project. And then in 2011, we had the Terre project on the law of obligations, which was actually quite good because then we had two projects. So there was a kind of competition with different ideas, and that was a good thing, I think. And so the French Ministry of Justice started to work on the reform of French civil liability around that time. And in 2012, an unofficial draft was not published because it was unofficial, but it was circulated among lawyers. And so it's still discussions. And then in 2016, we had contract law reform. And just after the reform was adopted, an official draft on civil liability was published by the French government. So here we really had a draft, and a consultation was opened where all stakeholders could make suggestions, make critiques and suggestions. So several hundred people did contribute. And on the basis of these contributions, a new draft was published. Well, a reform bill was published in March 2017. So maybe maybe after the conference, I mean, we can see if some documents can be made accessible to you if you wish to. So the reform bill is accessible in French on the internet, but it can be sent to you. And it was also translated into English. There's a very good translation into English. So if you don't speak French, then you can access the text in English, which is very useful. So we have this reform bill, which dates back to March 2017, and it's still the official, it's still the reform bill which is on the table. So at the end of this conference, I will say a few words about what will happen now, but basically the text we have and the basis on which the reform should be made is this 2017 reform bill. So it is this bill which I would like now to present to you. So what will happen tomorrow? Well, tomorrow, if reform takes place, it will take place on the basis of this bill. So we should look at the content of the bill. So we'll see what's not new in the bill. So what's in the bill which was already there in French, civil liability law before. Then we'll see what is new in the bill, and we'll see what is not in the bill. And then I will say a few words about the future, of course, of the bill. So what was already there? So what do you find in the bill which is already in French civil liability law? Well, the first point which must be made clear is that the bill is, first of all, I would say, a restatement of current French civil liability law. In other words, most of the bill's provisions do reflect existing legislative provisions, or they codify existing case law rules. So the aim of the bill is not to make a revolution. It's not to turn things upside down. The first aim of the bill is to confirm existing law, but to bring into the code many of those rules which have been developed by the courts, and so which so far have been only case law rules. And what the bill would like to do is to turn those case law rules into official legislative rules to make the law more clear and more accessible, as already been said. So if you look at the bill, so I will answer, of course, to the best of my ability, all the questions you might have. I won't be looking here into the bill into too much detail. So I'll be mentioning some provisions, but we can discuss them in more detail afterwards if you want. But so if you look at the bill, then you will see that almost all basic rules of French liability law are being carried over. So for example, and I'm taking things in the order of the bill. So the non-cumul rule, so the rule whereby you've got no option. When you've got a contract, it's always liability in contract which applies. This non-cumul rule is to be found in the bill. That's Article 1233 in the bill. We also accept in the bill compensation of loss of chance, which means we keep this very broad conception of damage. We do keep, of course, the general clause on liability for fault, which is a kind of trademark of French law. So we do keep this very general provision, but only with a modernized formulation. We also keep liability for the action of things, of which French lawyers are very proud. Actually, some years ago, 10 years ago, I wrote an article suggesting that we could do without this regime now, because I think it has, well, it's not very useful anymore today. But this suggestion was met with fierce hostility, because French lawyers are very proud of this judge-made regime. So even if we don't use it very much, we regard it as a, really it's as part of our legal identity. So there's no question to exclude it. So we keep liability for things. We do keep, I didn't mention that, but we have, as in most legal systems, a full compensation principle whereby when harm is to be compensated, then it must be compensated in full. This is not in the civil code, but this has always been accepted by the courts. And this, of course, is confirmed by the bill. And also we keep, for example, extra strict liability for traffic accidents. So most of the, I would say, the distinctive features of French civil liability law are being upheld in the bill. But then, of course, there are also some changes which are suggested or which are, well, proposed. First of all, and this I think is a very interesting trait of the bill, the bill makes an effort at defining the notions used in civil liability, and also tries to establish some distinctions which so far had been present in French liability law, but had only been implicit. So the project tries to make things, you know, clearer and more structured from a conceptual point of view. So, for example, you find in the project a definition of compensable loss. You find a definition of fault. You find a definition of the full compensation principle. So, in that respect, there is an attempt, I would say, to also to rein in a little bit the discretion of judges by really offering definitions. That's an important thing. Second, there's a distinction which is introduced between what we call harm and loss. So for those who speak French, harm is, well, translates dommage, and loss translates préjudice. So let me explain you shortly what's the idea behind that. If through my fault I break your leg, I'm liable for that, but I'm not going to repair your leg. I'm not a surgeon. So if I break your leg, what I'm going to do is that I'm going to compensate the losses which flow from your broken leg. So what are those losses? They can be patrimonial. Because of your broken leg, you've got medical expenses. You might have lost revenues. So those are patrimonial losses which I must compensate. And there are also non-patrimonial losses. For example, your pain and suffering. So what I do usually, if I cause harm, is to compensate not the harm itself, but the consequences of that harm. And so we have come to distinguish between the harm itself, which we call dommage, and the consequences of that harm, which can be either patrimonial or non-patrimonial, which we call préjudice, and which you can translate in English as loss. And this distinction is already present in French law. It has proved very useful to clarify the rules about bodily injuries, because it works especially well in case of bodily injuries. And the project, the bill, suggests that the distinction should really be adopted across the board and should be generalized, which I think is a good idea. And also, still on the conceptual level, the bill proposes or adopts a new conceptual approach of liability for others. So maybe I don't have time to go into that now, but I can answer questions, of course, if you want. But there's really an attempt to have a clearer and more convincing conceptual approach to civil liability, which appears on several occasions in the project. Then if you turn to the relationship between contract and tort, which is an important topic in French law, there again, you've got some new aspects in the bill. First of all, liability in tort and liability in contract are regarded as two species of one same genus, which is the reason why the bill is for the reform of civil liability and not just liability in tort. So it includes both liability in tort and liability in contract. this is an old debate in French law as well as in other legal systems, but contractual liability obviously is somewhere in between contract and tort law, in the sense that it's liability for a breach of contract, but at the same time it's liability. So it certainly has something in common with liability in tort. And so you can take basically two approaches. You can say liability in contract is first of all contract. Of course, it has some common features with liability in tort, but it's first of all contract, so it should be regulated with contract. And then you've got another approach which says liability in contract is actually closer to liability in tort than to contract, because it's liability first of all. The first approach, so regulating liability in contract with the rules on contract, is of course the majority approach which you find in most legal systems. But some legal systems do take the approach that liability in contract is closer to liability in tort. That's the case, for example, of the Austrian Civil Code, which has one set of rules for both for liability in contract and liability in tort. So in France, we have had this debate for some time, and the bill adopts the second approach and chooses to regulate liability in contract with liability in tort and not with contract. I personally do not agree with this approach, but of course, I'm not the legislator. So, this is made clear in the bill, because in the bill, if you look at it, you will see that most rules are presented as being common to contract and tort. And there are only certain rules which are said to be specific to contract or specific to tort. I'm not sure that this approach is totally convincing, and there are, I think, some small flaws in the ways in which the bill does try to implement this approach, but nevertheless, that's a very distinctive feature of the bill. Another interesting feature is that while the non-cumulative rule, so the non-option rule is kept and maintained, it is inverted in case of personal injury. What does that mean? That means that in case of personal injury, so that means in bodily injury, then it is always the rules of tort law that shall apply. So not the rules of contract, but always the rules of tort law. So the idea is that if you suffer personal injury, so bodily injury, you can only claim damages on the basis of the rules of tort law and not on the basis of the rules of contract law. So here again, you have no option. But instead of giving priority to contract law, as is normally the case in French law, priority is given to tort law. So why do we have this rule? Well, until now, the non-cumulative rule and the fact that we are bound to apply contract law on certain occasions means that bodily injuries, which will sometimes be compensated on the basis of contract law and sometimes be compensated on the basis of tort law. And this can lead to different results, even though claimants are in very similar situations. For example, if you take a classic example, if there's an accident in a train station and two people are hurt by a train which comes into the station, and one person has a train ticket, the other person doesn't have a train ticket because he's just he's coming to bring someone into the train, then one person will be compensated under contract and the other person will be compensated under the rules of tort. And this can lead to discrepancies, although the two victims are basically in the same situation. So many lawyers in France have come to think that this was not a good solution. And so the decision has been taken in the bill to always compensate bodily injuries on the basis of tort law. The basic idea behind being also that, well, personal safety is not a matter of contract. It's kind of outside the contract because society, so to say, owes you safety, whatever the context. And then we also have in the project a rule on liability of contracting parties to third parties in case of breach of contract. I've told you that we have this very surprising solution in case law since 2006, whereby any breach of contract is a source of liability in tort to third parties. This has been very much discussed and debated in French academia. And so we have a rule on that in the project, in the bill, which I must say is not convincing at all. So I'm not going to talk about that, but it certainly should be changed. Also, we have many provisions in the bill are devoted to the compensation of personal injuries, so bodily injuries, because this in practice is, I would say, is the heart of civil liability. So we still retain the French approach in the sense that there is no set list of protected interests and all interests are protected. But while all interests are protected, a clear priority is given to bodily injuries in the sense that the draft makes it easier to compensate bodily injuries than to compensate other types of losses. So how is it so? Well, first of all, as we just said, it's only tort law that applies in case of bodily injuries. Comparative negligence, for example, which normally applies, should not apply in case of bodily injury, or whether it should only apply if the claimant was grossly negligent, which means that the normal negligence of the claimant will not reduce his right to compensation. The duty to mitigate also, that's Article 1263. The duty to mitigate doesn't apply to bodily injuries. Exclusion clauses, which are normally valid, do not apply in case of bodily injuries. That's Article 1281, and still other rules. So while all interests are protected, there is a clear priority given to bodily injuries. The compensation of bodily injuries is made easier. Also, detailed rules are set out for the reparation of losses resulting from personal injuries. So for example, Article 1269 provides for a non-exhaustive typology of items of loss so that there can be some kind of harmonization in case of bodily injury. The bill also says that we should use a single medical scale to measure functional deficiency, so to measure exactly how the magnitude of the injury. And also the bill says that we should create, the government should create a compensation index for the assessment of some items of extra-patrimonial losses. What does this mean? While in theory we apply full compensation doesn't mean very much when it comes to non-patrimonial losses. If you suffer because you've been injured, or even if you suffer morally because your spouse has been killed in a traffic accident, you need to be fully compensated for your suffering. But how do you compensate for that? How do you measure suffering? It's just not possible. So in practice, to avoid discrepancies between courts, it is suggested that a compensation index should be created so that victims in the same situation basically get the same amount of money, even though they will go to different courts. Also, a striking feature of the project of the bill is that it tries to develop the non-compensatory functions of civil liability. So what is that? Well, first of all, the bill does introduce a duty to mitigate. I think you all know what the duty to mitigate is. The idea is basically that a claimant should not get compensated for the loss which it suffered because of the tortfeasor, but which claimant could have avoided by taking reasonable steps. So if I take a classic contractual example, if I sell you some fruits and vegetables, in big amount of fruits and vegetables because you're a supermarket, and you do not take delivery of the fruits and vegetables, I can either remain idle, and of course the fruits and vegetables will get lost, or I can try to find another buyer for those fruits and vegetables while they're still good. So in many legal systems, you have a duty to mitigate. That is, you've got the duty to, in such a case, to try and sell your fruits and vegetables to someone else so as to minimize your loss. In French law, until now, there is no duty to mitigate. The French courts have consistently said, no, there is no duty to mitigate. So even if you don't make reasonable efforts to mitigate your loss when you're the victim of, tortfeasor, you will be compensated in full. And so the project does introduce a duty to mitigate, but only when there is no bodily injuries. So it doesn't work in case of personal injury. The idea being that we don't want to force people to undergo medical treatment. So you should never be forced to undergo medical treatment, even if that would reduce your loss or your harm. But as soon as there is no bodily injury, then you should mitigate your loss. Besides, the project also creates an injunction for the cessation of unlawful action. So regardless of any actual loss or any actual harm being already caused, you can bring an action to have an action stopped if that action can result in your being injured or your suffering damage. So that's basically an action for an injunction, to get an injunction so that you won't suffer harm, even though harm has not yet been caused. We already have that, but it's not very clear. So the project wants to generalize this solution, which exists elsewhere. And then probably the most debated provision in the project is Article 1261, which introduces a civil penalty. So what is a civil penalty? Basically, civil penalty is punitive damages, but punitive damages that do not go to the claimant, but that go to the state. So what the bill says is that in some circumstances, when there is a very serious fault, the defendant may have to pay a civil penalty. So it may have to pay damages in excess of the harm that was actually caused, but those damages in excess of the harm will not go to the claimant, they will go to the state. So why is it so? Why does the why does the bill not introduce what I would call plain punitive damages? So punitive damages that go to the claimant. Well, there are basically two reasons. The first reason is a reason of principle, because in French law, we think that the full compensation principle is very important. And this means that the claimant should not get any richer from the tort he suffered. So, and the problem, if you get real punitive damages, is that the claimant can get richer because he will get damages in excess of the harm he actually suffered. So the problem we have in France with plain punitive damages is that they are not in line with the full compensation principle. And besides, there is a practical problem. If you take the example of let's say, a producer of pharmaceuticals, which commercializes, which puts into circulation a pharmaceutical, for example, a vaccine. Let's take an example which is topical. Let's say that a company puts into circulation a vaccine knowing that the vaccine is actually defective and that it will cause damage to many people. This can be equated with gross negligence, if not intentional fault. And so this might give rise to punitive damages. But then who should get the punitive damages? Because if you've got 10,000 victims, and if they don't sue all together, should the punitive damages go to the first claimant? So the first one who claims will get punitive damages, or should the punitive damages be split between all potential claimants, but you don't know who's going to claim? So it's quite complicated. In the United States, they do solve the problem because they've got class actions. So if you've got a class action, then you can split the punitive damages among all the members of the class. But if you don't have class actions, and in France, we don't have class actions, or at least we don't have class actions across the board, then deciding who should get those punitive damages is very complicated. So it's much easier to say that punitive damages should go to the state. And that's why the bill introduces civil penalty and not, plain punitive damages. But then, of course, if you have civil penalty, our claimant is going to use this provision because when you've got, so to say, real punitive damages, it does create an incentive for claimants to claim so that they will get punitive damages. If you only have civil penalty, will the claimants, ask for a civil penalty because they won't get any cent out of it. They won't get any euro out of it. So if you have civil penalty, it's not clear if claimants will have an incentive to ask for a civil penalty being imposed on the defendant. So other questions are raised by this provision. What is certain in any case is that when the bill comes to Parliament, it will certainly be the most disputed provision because, as you might guess, business circles are not very much in favor of punitive damages or civil penalty. So it's obvious that if the bill comes to Parliament, there will be a really very strong fight about punitive damages because business circles or pro-business, MPs will do everything they can to try and stop and avoid this provision. So it's not sure at all that we will have that, but it certainly will give rise to discussion. And then to end up on the presentation of the bill, you might want to ask what is not in it. I've talked about what is in it, but of course there's also all the things that could have been in the bill and which are not in the bill. So first of all, there is no new strict liability regime. Both academic projects which were drafted before the bill, so the Catala project and the Terre project, both of them suggested that we should create in French law a new liability regime, well, strict liability regime for dangerous activities. You might know that a certain number of legal systems like Italian law, Dutch law, have a general strict liability regime for dangerous activities. And while we have many strict liability regimes in France, we don't have a general liability regime for dangerous activities. So many academics suggested that we should adopt such a regime, but in the end, when it drafted the bill, the government decided not to introduce such a regime. So on that count, the bill is rather, you could say conservative. Also, you find almost nothing, well, there's just one provision, but otherwise you find almost nothing in the bill on the issue raised by scientific uncertainty, artificial intelligence, and new technologies generally. This, of course, can come as a disappointment because those are, so to say, the hot topics in civil liability today. What should you do in case of scientific uncertainty? We certainly will have questions with, vaccines against COVID. If we have side effects and we're not sure if they can be related to the vaccine, what should we do? There are, of course, many questions popping up with artificial intelligence. How should civil liability apply to, autonomous vehicles and things like that? So we've got many questions around that now in France and in Turkey. I mean, I think in all countries, but we've got no provisions or almost no provisions on that in the bill. How come is it so? Well, the answer I think is quite obvious. Is that while there is a lot of discussions about those topics right now all over the world, I don't think that anyone has yet come up with rules that are totally convincing we're still, looking for the good rules. Typically, if you take artificial intelligence, we're still wondering what the rules should be that should apply to autonomous vehicles or artificial intelligence. So it's probably a bit too early to have convincing rules on the subject. So the choice of the French government was to keep those questions outside the draft. It's a bit disappointing, but on the other hand, it's very hard to suggest, hard and fast rules which could apply in those fields. And then there's nothing in the bill on collective redress, such as class actions. But the reason for that is well, first of all, it's regarded in France, first of all, as a question of procedural law and not as substantive law. And also, we have adopted recently separate legislation on the subject. So as I said, we don't yet have class actions across the board, but we have created class actions in several contexts, especially in the context of pharmaceuticals. And there's also legislation from the European Union coming on the subject. So this has been left out of the bill. So here you have a very general view of the bill. And the question, of course, is, well, what will happen next? Because as you noticed, the bill dates back to April or March 2017. So it's nearly 4 years old now. So what has happened since the bill was published? Well, since the bill was published, there have been a lot of discussions on the bill, and we know that the Ministry of Justice, which drafted the bill, is still working on it. They're making small changes to it, but it hasn't yet come to Parliament. Why so? Well, I don't know how things work in Turkey, but in France, it's quite clear that civil liability has never been a priority for the legislator. And especially not now with the COVID and other problems. So the legislator has got many other things to do, and they're not very worried about civil liability. At the same time, well, you don't need a very big slot, in the parliamentary agenda to discuss a reform bill on civil liability. It's not that complicated. So. The other problem is that experience shows in France that if you want to have civil liability reform, or civil legislation, you need to have a Ministry of Justice who is really interested by the subject and who will push the subject forward. And over the last 4 years, we've had two ministers of justice and who haven't been very interested in civil liability. One of them was a public lawyer, so presumably she was more interested in public law than civil liability. And we've had now for a few months a new Minister of Justice, but he's a criminal lawyer, and he's got a lot to do with COVID, with terrorism. So civil liability is not a priority for him either. So reform will certainly take place. I don't know when it will take place, but it's still on the agenda. And civil servants in the ministry are pushing the project. So eventually, I think the reform will be adopted, and it will be adopted along the lines of the bill I have just presented. Of course, there will be some changes, but the basis of the new legislation will be the bill which I have just presented. The question is, when will that happen? Obviously, I don't know. I think the chances that it will happen before the next presidential election, which comes up in about 15 months, I think the chances are low, are not very important, but maybe it could come in 2022. But once again, the reform is on the agenda, and if it does take place, it will take place along the lines of this bill, which I just presented to you. So thank you very much for your attention.
Thank you very much for this satisfying and interesting presentation, Professor Borghetti. Now, please, all are welcome to share their questions or comments and contributions, of course. But I would like to remind that we have reserved 30 minutes for discussion. So all are welcome, please. I'll check the chat as well. So we have a question at the chat section. I would like to read the questions on the chat for the recording. So Dr. Günhan Gönül Koşar is asking, she says, thank you very much for your presentation. I would kindly like to ask a question on fault liability. Under French law, a person can be at fault even if they lack power of discernment. So a 4 years old or mentally disabled can be at fault and be held liable for damages. You mentioned that the insurance system prevents problems that might arise thereof. Could you please provide more info on the insurance system? Isn't there a cap on the liability of the insurance company? Let's say if the child mentally disabled causes a damage in the amount of 10 million euros, will the company pay for the entire damage? Or if not, what happens for the gap in between, she says.
Thank you for the question. Well, in France, normally everybody has insurance for his house. So whether you are the owner of your house or whether you only rent your house, you normally have insurance for your house. So you have got household insurance. And in the household insurance, there's always included insurance for civil liability, especially insurance for damage caused by children. And there is no cap to this liability. So as soon as you've got household insurance, liability for damage caused by your child or even by yourself in the course of ordinary life will be covered by the insurance, and there's no cap. So if my child causes damage in the amount of 10 million euros, I won't have to pay anything, and the insurance will pay everything. But then it doesn't happen very often that children cause damage in the amount of 10 million euros. And in practice, it seems to work. And if you want to work to buy, I did that once. I wanted to buy civil liability insurance without household insurance because, well, for various reasons, and it's rather cheap. It must be around 200 euros per year, so it's not ridiculously cheap, but it's reasonable. And there you've got a full guarantee for damage you can cause in the course of your ordinary life. So it doesn't include traffic accidents liability, it doesn't include professional liability, but for everyday life you're covered and your children are covered. And this is actually a reason why I didn't mention that, but the French Cour de Cassation some years ago introduced a very surprising solution, because it said that parents were liable for damage caused by their child, at least for bodily injuries caused by their child, even if the child behaved normally. So we have a case where a child was playing rugby, it's a bit like football, he was playing rugby and he injured another child without being negligent. It was just bad luck, as can happen on in a football game. So he injured another child, and his father was found liable, even though there was no abnormal behavior from the child that had caused damage. And the obvious reason why this solution was adopted, even though this was not said in the judgment, but the obvious reason is that it's covered by insurance. And so it's the insurance that pays. And so far, obviously it's okay for insurers. The day when insurers say, we don't want to cover that anymore, then it will be a problem, and presumably we'll have to change the rules of civil liability. But so far, the insurers have accepted to, I would say, to play a game, and it hasn't been a problem for them to cover damage caused by children, for example, because obviously there are not many cases. or at least there are not many cases where very significant damage is caused.
Thank you very much. And I see that Professor Hüseyin Can Aksoy is raising hand. So please.
Thank you very much. It was an amazing presentation. I learned a lot and it was a real pleasure. I have two questions actually, if I may, but very short ones, I promise. First one, you talked about the civil penalty. And so how does I'm curious about hearing how the procedure works. Simply, would the claimant apply to the court, or would an independent administrative authority, for instance, interfere? I kindly request you to expand on that. And my second question is about non-criminal rule, which is inverted in case of bodily injury. You said that now you gave the example of a train crash, and there was a passenger with a ticket, and there was another passenger without a ticket, and the French law now accepted to subsume these two cases under tort law. But from a Turkish law perspective, which could also be said from a Swiss law perspective, perhaps, one could argue to subsume these under contract law, because contract law has some benefits in comparison to tort law for the party who is injured and who is claiming compensation. So could you briefly explain the differences between French tort and contract law, and which is much in favor of the damaged party who is asking for compensation? Thank you.
Well, thank you for the questions. Maybe I'll start with the second question. Well, that's a tricky question because, so I mentioned the non-cumulative rule, whereby as soon as you have a contract, it's normally liability in contract which applies. And French lawyers usually regard this rule as, they take it for granted, they regard it as natural because it's been so for a long time in France, but actually it hasn't always been so. And the rule was actually developed in the 1930s. And why was it developed in the 1930s? Because at that time, the courts really developed strict liability in tort. And there was a risk that strict liability in tort would interfere with contract. So the non-cumulative rule, so the rule whereby you've got to apply contract law as soon as there is a contract or contractual liability, was initially devised to literally protect contract or the allocation of risks in contract against strict liability in tort. But then it came out that in some cases, well, liability in contract became more favorable to the claimant than liability in tort. So initially, liability in tort was thought to be more favorable to the claimant, but then it evolved in such a way that it's not always the case. Today, it's actually hard to say which is most favorable. It actually depends on the circumstances. Liability in contract, as I said, is normally strict, but then there are cases where the Cour de Cassation, so case law, says that liability is based on the violation of an obligation of means, obligation de moyens, as opposed to an obligation of result, which means that liability is in effect liability for fault. So it's like liability for fault, although it's in contract. Whereas liability in tort is, the basic provision is liability for fault, as I said, but there are many cases of strict liability in tort. So it really depends on the circumstances. There will be cases where liability in tort will be more favorable to the claimant, and other cases where liability in contract will be more favorable. So it's not really like in other legal systems where, for example, if you take liability for others in German law, it's clear that liability for others is more favorable to claimants in a contractual context than in a tort context. In French law, you really have to see on a case-by-case basis. So, because sometimes liability in tort will be strict, sometimes it will be based on fault, and the same is true for liability in contract. so that makes things rather complicated, and that's the reason why the bill suggests that it should be liability and tort across the board, with the idea that in most cases it will be strict liability that applies. Because if you take liability for traffic accidents, if you take product liability, if you take liability for the action of things and other regimes, you've got many cases of strict liability. So on average, it's probably more favorable for claimants to claim on the basis of tort law. But, well, things right now are a bit complex. So one reason for this rule, whereby the liability and tort should apply whenever there is a bodily injury, is also to make things simpler, because right now it's quite complicated. I hope this more or less answers your question. If I turn now to civil penalty, I can show you the provision on civil penalty. So it's Article 1266(1) of the draft. And as you see, or as you can see, if you read the provision, it is not an independent, administrative body that can, ask for a civil penalty. It must be the claim. Well, the case must be brought by an individual. Well, by a claimant, an individual claimant. If the case is brought by the claimant, then the Ministère Public, so basically the Attorney General, which can also be present in litigation in civil matters. So the Attorney General can also request a civil penalty. And the idea why the minister, well, the Attorney General should be granted this possibility is that there is a risk, of course, that the claimant himself will not ask for a civil penalty since he won't get any money out of it. So the idea is that the claim should be brought by the victim, but if the victim brings a claim, even if the victim doesn't ask for a civil penalty, then the Attorney General can ask for a civil penalty. But the initiative must come from a claimant, from an individual claimant. And so if you look at the provision, then you can see that there are many conditions which are set. Actually, this provision was influenced by a provision on civil penalty which exists in competition law, and the idea that the penalty cannot be higher than 10 times the amount of any profit made, which you find in the third paragraph of the provision, is basically a cut and paste from competition law. But whereas such a cap makes sense in competition law, it's not clear if it, well, rather, excuse me, it's paragraph 4 that says that the penalty can be as high as 5% of the highest amount of the defendant's revenue realized in the course of one of the years before before which the fault was committed. So paragraph 4 is a bit complicated, but it's basically a cut and paste of competition law. But I think it doesn't really make sense in the context of civil liability. I mean, the reference to the highest amount of the revenue, well, that makes sense in competition law. It doesn't really make sense in civil liability. So the provision needs to be redrafted, I think, and it certainly will be redrafted. It's quite certain that it will not be adopted as such. There will be, as I said, a lot of debate, and even if the provision is adopted, it's certain that it will be modified in one way or another. But then it's also likely that if we adopt such a provision, the principle of civil penalty will be retained, rather than plain punitive damages, because we're not very comfortable with the idea of giving the extra money to the claimant. Of course, the Americans would tell you, you need to give the extra money to the claimant so that he will bring a claim. So it's a very strong incentive, of course, but it's not really the way in which French law looks at things.
Thank you very much, Professor Borghetti. I saw that Professor Özsunay is raising hands, so please, Professor.
Wonderful, thank you. First of all, I would like to thank our colleague. This presentation was very clear, informative, and comprehensible. So therefore, I have been, I have got a lot of information about the revised Code Civil, or the revised parts of Code Civil. By the way, we have got information on the salient features of the bill. What I would like to say, just for get more information, what about the impacts of the revised parts of Code Civil on the, for instance, Quebec Civil Code or Louisiana Civil Code? Because I have seen the translation of the Code Civil, and some colleagues from Louisiana also participated in the translation activity. Probably some parts of Code Civil had impact upon, because there are also revisions on the one hand in Quebec, on the other hand in Louisiana. Can you tell us some concrete impacts on this point? By the way, I see here my colleague from Maastricht, Van Erp. So greetings from Istanbul. So many years to see him, a pleasure for me. Thank you so much.
Thank you. So as you know, the Quebec Civil Code was reformed in the 1990s. The new Quebec Civil Code came into force in 1994, and the Louisiana Civil Code was also revised. I don't remember the exact year, but it was revised before the French Civil Code. Well, so obviously the new French Code cannot have had an influence on those reforms which took place before. They might have an influence on how the new, for example, on how the new Civil Code of Quebec is implemented. Just to give you an example, on contract law, the French reform introduced, but accepted that a contract can be modified by the judge in case of a major change of circumstances, which is something very new, because until 2016, French law stuck to a very strict conception of the binding effect of contract. So even in the case of a major change of circumstances, the debtor had to perform the contract. And the reform has changed that. And recently there was a very interesting case in Quebec about the change of circumstances, and the Code Civil of Quebec sticks to the, I would say, to the classic solution, so the former French solution, whereby you cannot modify the contract. And when the case came before the Canadian Supreme Court, the Supreme Court said, well, the French law has now accepted that the contract can be modified by the judge in case of a change of circumstances, but French law has done that through the legislator. So I, as a court, cannot change that in Quebec law. So as long as the Quebec Civil Code doesn't provide for a modification of the contract in a case of change of circumstances, the courts cannot change this solution. It's only for the legislator to change the solution, and to say that the Canadian Supreme Court based itself on the new French Civil Code. So
thank you so much.
You can have an influence on that. There's another question is, to what extent were those codes, so the Quebec Code or the Louisiana Code, taken into account when drafting the bill? Well, I think the influence was limited. Generally speaking, since French tort law is very specific, it's not very open to foreign influences. But there is actually, if you look at French scholarship today in tort law, you clearly have two trends. You've got a very classical trend, which is, I would say, very Franco-French, and which wants to, to make French civil liability even broader than it is today. And this trend was very strong in the Catala project, so in the first academic project. And then you've got another trend, which is a minority trend of lawyers which are, I think, more open to comparative law, and which would be rather in favor of, restricting a little bit French civil liability. And this trend was quite clear in the Terre project. So you've got those two conflicting trends. And when the French Ministry of Justice started to work on civil liability reform, it obviously had to make a choice between those two trends. And while it tried to a certain extent, to make a combination of the two academic projects, it clearly stands closer to the Catala project than to the Terre project. So the reform bill which I presented goes rather in the, is true to the French tradition of making liability as broad as possible. And well, there are some foreign influences, but they're quite limited.
Thank you very much. Now we have a question from Professor Ali Can Budak.
Hello. Thank you very much, Professor. I was trying to write a text to the chat, but then I realized that we are also allowed to put our questions in language. I have two questions, actually. I know the time is limited. Just to make it short, is there any amendments in the reform bill about statute of limitations? And my second question would be about the entry into force of the amendments. So both the amendments which has already been made, but also for the future. And what about the inter-temporal aspects of the thing? Are there anything you would like to tell us about that?
Well, on the first question, there are no provisions on prescription or the statutes of limitation, because as was mentioned by Professor Osunay in his initial presentation, we actually had a reform of prescription about 13 or 14 years ago. So we're not going to change that. The basic rule in French law is that prescription or the basic statute of limitation is 5 years. So it's 5 years as of the moment when the claimant was able to bring his claim. So knew of the elements which were necessary to bring his claim. That's the basic rule, but we have a very important exception in case of personal injury, because in case of personal injury, we have a 10-year prescription delay, which starts to run as of the stabilization of the claimant's condition. So it's a 10-year delay starting to run when the physical state of the claimant stabilizes. Which means that in some cases, I mean, if you get, for example, I don't know, cancer from a pharmaceutical, your state will not stabilize until you're dead, basically. So it means that there will be no prescription. We have a very general statute of limitation in case of personal injury, which is in line with what I said about compensation of personal injury being made as easy as possible. But you've got no provisions on statute of limitations in the project, in the draft bill. So that's on your first question. Your second question is a very good question. What about the inter-temporal effect of the bill? Well, that's also something I could have mentioned in the things that are not in the bill, because the bill doesn't say anything about when it should come into application and how it should apply to past facts. And this is not very clear. This is actually, well, it's a rather an obvious point which you raised, and I brought it to the attention of the ministry when I was talking with them, and I'm certainly not the only one to have done that. And they basically told me, Well, we'll see that later. So I don't know I don't know how they're going to do. What is clear, I think, is that they will have to negotiate that with insurers, because, as I said, the system in France works quite well, but it works quite well because it is supported by insurance, and so insurers will have their word to say. Because if the rules, well, some of the rules will change, and so the insurers will have to adapt. And so I think that this will have to be taken into account when deciding about the date at which the new provisions will enter into force, because insurers may have to adapt some contracts, and so we have got to leave them time to do so, because we need them. I mean, we need them for the system to work. Once again, French civil liability is very broad, but it can only be so broad because there are insurers behind. So we need to take into account what insurers will say. The paradox actually in France is that lawyers, writing on civil liability are often very critical of insurers, saying they're the bad guys, because of course they're always on the side, well, they're always on the side of the defendant, on the one who caused damage. So insurers are often seen as the bad guys who don't want to pay. And of course, sometimes insurers are not very nice. They don't want to pay. I think we all experience that as, insured people. But on the other hand, they are an essential part of the system, because we can have such a broad liability only because insurers are supporting the system. So we can criticize insurers, but we need to be aware that it also works thanks to them. Because if there was no insurance, then we could never have such a broad liability. Especially, we couldn't have so many cases of strict liability. It's very clear for traffic accidents, for example. We can have extra strict liability for traffic accidents because there is a compulsory insurance scheme behind. Otherwise, it would not be possible. But to come back to your question, it's not clear how it will apply in time. But that is a very good question. So it will have to be answered before legislation is passed.
Thank you, Professor.
Thank you very much. Now we have a question from Professor Özgün Çelebi. Please, Professor.
Thank you very much. Thank you, Monsieur le Professor. It was a very nice presentation, and thank you to the Kadir Has Law Faculty, of course, for this wonderful organization, for this wonderful encounter. The Cour de Cassation in France has been a very important part of civil law, as you have highlighted, because the case law has played a very important role, a very significant role. But now that their discretion will be quite limited, especially through the insertion of definitions, I wonder how did the Cour de Cassation reacted to this process? Are they enthusiastic about it? Do they support this project? Do you have any comments about that? Thank you very much.
That's also a very good question. We all know that the law is not only a matter of rules, and certainly not only of rules in the codes. It's also a matter of how these rules are interpreted, are put into application. And this is certainly very true in France, where, as you said, the courts have played a great role in developing civil liability, but they have also taken great liberty with the provisions of the civil code. And so they've taken habits, and I would even say they've taken bad habits, because they've taken the habit of not, of disregarding the law. The code, saying, well, there's not much in the code, so we're going to make the law. And they had reasons to do that when there was practically nothing in the code. If reform takes place, and if now we have a code with, maybe 80 provisions on civil liability, where we used to have only 5, then obviously it should limit the discretion of the courts. What I don't know, and that's basically your question, but it's a very good question, is to what extent will it change the practice of the court? My fear is that the French Cour de Cassation will keep disregarding the code because it has been doing so for nearly 200 years. So there is, to me, for me, a serious possibility that they will not say, of course, but what they will do is consider that, okay, we've got a nice code, but we're going to keep doing what we've always been doing. So I don't know. Typically, when the code tries to limit the discretion of courts, but when the bill wants to limit the discretion of courts, I don't know if it's going to work. Just to give you one example, if I take the definition of fault, the project, I'll show you that very quickly. The project gives a definition of fault at Article 12. Fault is a violation of a legislative requirement or a failure in the general duty of care or diligence. So that's very broad, okay? But it's nevertheless a definition. And as I said, so far, the Cour de Cassation did not have to abide with any definition, so it was very free to do what it wanted. Just to give you an example, there's a case I love. It's a 2000 case from the Cour de Cassation. There was someone, two persons, climbing on a walk, and the one who was climbing ahead fell, and so it made the other climber fall as well. And so the other climber who was injured brought a claim against the first climber, or rather it brought a claim against the insurer of the first climber, saying, well, I was injured because of the first climber falling. And when it came before the appellate court, the appellate court said, well, I see no fault because, okay, the first climber fall, but I see no fault. I mean, basically bad luck. So no fault, no liability. It came before the Cour de Cassation, and the Cour de Cassation quashed the decision of the appellate court saying, well, the mere fact of falling is fault. And I mean, there were no explanations given, but of course, it was clear that the Cour de Cassation wanted to compensate the claimant. And since also there was insurance, it thought that it was fair to do so. But you see, it could do so because there was no definition of fault. If the court had to abide with a definition of fault, could it have, handed down the same decision? Because if there had been a definition of fault, the Cour de Cassation would have had to explain how the facts of the case, matched with the definition. And I think it could not have done so. So if there had been a definition of fault, I think that such a decision could not have been handed down. So if now we have a definition of fault in the code, will the court take it seriously? If the court takes it seriously, then it will not be able to say that the mere fact of falling when climbing is fault. But there's also a possibility that the Cour de Cassation will say, will keep saying that the mere act of falling is fault, and will therefore disregard the new Article 1242, which you see in the project. So I'm sorry if I was a bit long, but I think your question is an excellent one. We can change the black letter rules. I don't know to what extent we will change the mentality of the Cour de Cassation. I think in the long run, they will have to change. They will have to evolve. But in the short run, I think they will be tempted to retain their traditional approach. And so I think it will take time before the reform is fully implemented, because it will take time before judges change their attitude to the code.
Thank you very much. Thank you.
So we have another question from Mr. Kaan Can Yıldırım. I will read it from the chat. He says, thank you very much for the informative presentation. I don't know if I misunderstood, but you mentioned that one of the reasons why the French liability system, despite the wide range of compensable damage and loss, still works is that the amount of compensations is generally not that high. How is this possible despite the full compensation principle? Where and how do you draw the line in French law?
Again, a very good question. Thank you very much. Well, first of all, as I said, the full compensation principle, I think, that's my personal opinion, but I think it doesn't mean much when you're faced with non-patrimonial losses. Because when someone claims damages because he suffered, either physically or morally, or because he's physically impaired, he cannot use his leg anymore, or something like that. compensating with damages is like replacing apples with bananas. And so you cannot really speak about full compensation. If I take an obvious example, if a parent loses a child in an accident, he or she will get damages for that, but it will never be full compensation. I mean, you can give me 1 million euros. If I've lost my child, it's not going to be full compensation. There's no relation between what I lost and what I get. So first of all, in case of, non-patrimonial loss, you cannot really speak of full compensation. And here, so it's very difficult, as I said, to make comparisons between countries for a various number of reasons. But the few comparisons we have suggest that for that kind of losses, French law is probably not as generous as other laws, such as, for example, German law. So I think that for non-patrimonial losses, you will get more in other countries than in France. And here, full compensation is not really the issue, because anyway, you cannot really measure that loss in terms of money. Now, if you turn to patrimonial losses, well, when someone lost, a salary, for example, you earn a salary every month, and because of the accident, you were unable to work during 6 months. So you lost 6 months of salary. So that's fairly straightforward. And of course, you will get full compensation in French law. But if you take, for example, damage or loss caused by anti-competitive behavior, so, a company breaches the rules on competition law, or two companies, agree on prices so that prices go up, and so clients will pay more than they should have paid. It can be very difficult to calculate the exact loss which was suffered. You need to go into complex economic calculations. There can be debate, or for example, counterfeiting. I'm the owner of a trademark, and someone, commercialized products under this trademark, although they had no right to do so. What exactly is my loss? How do you calculate that? Well, it's very difficult, and French courts seem to take a very conservative approach in those cases, where also because, if you take English or US law, you will have the expert witness system, whereby each party will come with its own expert. There will be a battle of experts. So it's very expensive for the parties, because they will have to pay for the experts, but then they will have, the judge will have very sophisticated opinions on how to calculate damages in the case. In French law, in ordinary cases, we don't have such sophisticated expertise. So in complex cases of economic loss, it will also result sometimes in economic loss being, I think, undercompensated. So I think that's another explanation. As soon as economic loss is difficult to assess, French judges tend to be rather conservative, and certainly more conservative than judges in other legal systems. I mean, in some other legal systems.
Thank you very much, Borghetti. And now I would like to give the last word to Professor Başak Baysal, the Dean of the Faculty of Law. Please, Professor.
Thank you very much. Thank you very much, Dr. Topukçu. One last question. I know already your opinion on that, but you know already this question of mine. Reforming French contract law without reforming civil liability law. I'm very curious about your idea, just because now and since years you have French contract law reform, and in the bill there is a lot of regulation on civil liability, contract liability. And what was the purpose to regulate two liability system differently and separately? Yes, this is my last question. Thank you very much for the excellent presentation.
I'm sorry, Başak, can you, why are, you said why are liability in contract and liability in tort
yes.
treated separately?
Yes, I mean, contract law reform is already made in French law, yeah. But torts and contract liability, there is a lot of regulation on contract liability also in the bill. and I never understood why you didn't do that. I mean, at the same time. I mean, frankly.
I don't really know either. That's the problem. No, well, the thing is, when the government started talking seriously about the reform of the law of obligations, so initially the reform was to encompass contract law, civil liability, and the general rules on obligations. And the government thought that, especially as far as the general rules on obligations are concerned, like on the transfer of debt and that kind of things, those rules can be very technical, and at the same time they have a huge importance, for example, for banks. So the government thought those are very technical rules, and we don't really want them to be discussed in Parliament, because the risk is that in Parliament, the rules which have been very carefully, prepared and thought and devised, the risk is that they will be altered by members of parliaments who are not specialists. You might not agree with that. I mean, it's a certain conception of democracy, of course, but nevertheless, that was the fear of the government, that basically Parliament would upset the machinery which had been constructed, especially as far as general rules on obligations is concerned. So what the government wanted was to stop Parliament from looking at certain provisions which it thought were too technical. So what government said was, and in France you have the possibility to, the government can get an authorization from Parliament to take legislation in a field which normally would be the responsibility of Parliament. So Parliament can give an authorization to the government to basically pass a law, which normally should have been passed by Parliament. So government went to Parliament and said, we want to get an authorization to reform the law of obligation. But then Parliament said, no, you're not going to get an authorization to reform the whole of the law of obligations. I mean, that's very important. That's all business. And so basically government said, okay, we're not going to reform everything. So just give us an authorization to reform part of the law of obligations, and you'll reform the rest of it. Okay, so we'll share that, we'll make a deal. We do part of the job and you do the other part. And so the Parliament was eventually convinced, but it was actually very difficult. Even though the government had a majority in Parliament, it took them a long time to convince Parliament. But in the end, they split the law of obligations, and they said, okay, contract law and the general rules on obligations is for government. They will reform that first, also because it was believed that it would go faster. And then civil liability will be for Parliament. And the official reason for splitting things that way was that civil liability raises more, social issues than the law of contract. I'm not totally convinced, but it's true that associations of victims, for example, victims of pharmaceuticals and things like that, they're of course more interested in the reform of civil liability than in the reform of the general rules on obligations. So it's true that it was probably a more political dimension to the reform of civil liability. So both parties agreed that government could take the law of contract and the general rules on obligations, and Parliament would retain civil liability. So government made its part of the job. It reformed the general law on contract and the general rules on obligations, which I haven't mentioned, but which are also included in the 2016 reform. And Parliament was left with the task of reforming civil liability, but on the basis of a project presented by government. And so we have the project, but it hasn't gone to Parliament yet. And we do not know when it will get there.
Thank you very much. I think, this is the end of the conference. Let me say a few words. First of all, in English, but since last week, it's a kind of tradition for me. Since last week, it's a funny word, but I will finish if vous permettez en français. Enfin, depuis 2 heures, on a parlé en anglais, donc c'était une discussion, mais je voudrais quand même remercier à mon cher ami et à mon cher collègue, Jean-Sébastien, donc en français. I did it last week with Professor Oberson from Geneva. I will do it with Professor Borghetti also. I will finish in French. And on s'est rencontrés d'abord à Istanbul, je pense que maintenant, enfin presque 10 ans. Et donc après, on a continué de travailler ensemble. Enfin, on s'est rencontrés ici à Paris, à Hambourg, à Tokyo même. Et donc je pense que le monde des comparatistes est petit. Et cette conférence me fait énormément plaisir parce que ça m'a montré que même la pandémie ne nous a pas empêchés de travailler ensemble. Et donc, ça nous donne un grand espoir pour le futur. Et donc, je te remercie beaucoup de collaborer avec mon nouvelle université aussi. Donc, c'est avec Kadiras, la faculté de droit de Kadiras. Et donc, j'aimerais bien t'accueillir un jour ici à Istanbul personnellement. Et en attendant, bon, j'espère que ça ne va pas durer longtemps, mais en attendant, un grand merci, cher ami. Et vraiment merci pour cette conférence qui était excellente, mais je n'entends pas besoin de le dire, donc tout le monde est d'accord avec moi, je crois. Voilà, donc je laisse la parole à Dr. Topukcu et à bientôt, j'espère.
Merci beaucoup, à bientôt.
Thank you, dear professors, dear colleagues, and dear students for participating. And thank you very much, Professor Borghetti. So we are currently closing the session now, but we will continue with the seminar series of comparative law. So hope to see you again soon. Thank you very much. Have a good evening.
Thank you very much.